Federal judge dismisses Trump administration's lawsuit against Chicago's sanctuary policies. The Supreme Court's recent ruling on sanctuary cities has sparked a heated debate over federal power versus state autonomy. In a 64-page decision, U.S. District Judge Lindsay C. Jenkins, a Biden appointee, dismissed a Trump-era lawsuit targeting Chicago's sanctuary city policies, arguing that the federal government lacks standing to challenge state laws. The judge emphasized that Illinois' sanctuary laws, which protect local law enforcement from cooperating with federal immigration authorities, are shielded by the 10th Amendment, which reserves powers not delegated to the federal government. The sanctuary policies reflect a defendant's decision to not participate in enforcing civil immigration law, protected by the 10th Amendment and not preempted by the Immigration and Nationality Act. Jenkins wrote, "This stance challenges the notion that federal oversight can override state authority, framing the dispute as a clash between federal control and state sovereignty." The ruling highlights a growing tension between national immigration policy and local governance, with critics arguing that such laws disproportionately hinder federal efforts to combat illegal immigration. But here's where it gets controversial. While the judge dismissed the case, some lawmakers and advocates warn that this precedent could embolden future challenges to federal immigration regulations, potentially undermining the rule of law. The Justice Department did not respond to a request for comment, leaving the debate unresolved. Illinois Governor J.B. Pritzker praised the decision, stating it would safeguard state law enforcement from executing Trump's unlawful policies. He added, "Illinois will assist federal authorities when they follow the law, but we will not support violations of the law." The Trump administration had previously sued multiple sanctuary jurisdictions, including New York City and Los Angeles, citing conflicts over immigration enforcement. In a 22-page lawsuit, the DOJ argued that Illinois' policies obstruct federal immigration efforts, claiming they create barriers to cooperation between federal, state, and local agencies. The administration's actions have drawn criticism from both sides, with some calling it a strategic move to weaken state resistance to federal immigration policies, while others see it as a threat to civil liberties. As the debate continues, the question remains, can federal oversight of immigration be balanced with state autonomy? Or does the 10th Amendment ultimately protect local law enforcement from federal interference? The answer may shape the future of immigration policy in the United States. Chicago wins. Federal judge dismisses Trump's sanctuary city lawsuit. A major legal battle over immigration policies has reached a pivotal conclusion. A federal judge in Illinois recently ruled in favor of Chicago, rejecting a lawsuit from the Trump administration that sought to undermine the city's sanctuary laws. This decision has sparked intense debate about the balance between federal authority and local autonomy in enforcing immigration regulations. But here's where it gets controversial. The lawsuit argued that Chicago's policies, designed to limit cooperation between local police and federal immigration agents, undermine national efforts to enforce immigration laws. Critics claimed these laws prevent federal officials from identifying individuals who may be subject to removal. However, the court found that the city's restrictions were lawful and aligned with existing federal guidelines. Chicago Mayor Brandon Johnson called the ruling a victory for public safety, stating, "Our laws protect residents and ensure that police focus on the needs of Chicagoans, not political agendas." State Governor J.B. Pritzker echoed this sentiment, tweeting, "Illinois just beat the Trump administration in federal court." Meanwhile, Cook County's top prosecutor praised the decision, emphasizing that local communities must prioritize justice and crime prevention over political pressure. This case is part of a broader trend. The Trump administration has sued multiple cities, including Los Angeles, New York, and Denver, for resisting federal immigration enforcement. Chicago, a heavily Democratic city, has long been a sanctuary, strengthening its laws even during Trump's presidency. In 2017, then-Governor Bruce Rauner, a Republican, signed statewide protections that placed him at odds with his party. And this is the part most people miss. Sanctuary policies don't mean abandoning immigration enforcement. They refer to limits on local cooperation with immigration and customs enforcement, i.e., not a refusal to follow federal law. ICE still enforces U.S. immigration rules nationwide, but sanctuary cities aim to protect residents from deportation and foster trust between communities and law enforcement.
What's next? The lack of a clear definition for sanctuary cities means interpretations vary. Some argue these policies hinder federal efforts, while others see them as vital to protecting vulnerable populations. As the debate continues, one question remains. Should local governments have the right to set their own priorities when it comes to immigration enforcement? We want to hear your thoughts in the comments below.
Federal judge dismisses DOJ lawsuit against Illinois and Chicago sanctuary policies. Imagine a country where the federal government can't force local law enforcement to cooperate with immigration authorities, and cities can decide for themselves how to handle undocumented immigrants. This might sound like a recipe for controversy, but it's exactly what's happening in the United States, where sanctuary city policies are pitting local governments against the Trump administration. But here's where it gets interesting. A federal judge just dismissed a lawsuit filed by the Department of Justice against Illinois, Cook County, and the city of Chicago over their sanctuary city policies, saying the Trump administration lacks standing to invalidate state and local laws that limit cooperation with federal immigration enforcement. The judge's ruling is a significant blow to the Trump administration's efforts to crack down on immigration, and it's likely to have far-reaching implications for cities and states across the country. The lawsuit, filed in February, argued that Chicago's Welcoming City Ordinance and the Illinois Trust Act interfere with federal immigration enforcement and pose a threat to public safety. However, the judge disagreed, saying that compelling local law enforcement to assist with deportation efforts would be unconstitutional. This is the part most people miss. The 10th Amendment to the U.S. Constitution bars the federal government from commandeering states, and the judge's ruling reinforces this principle. The governor of Illinois, J.B. Pritzker, celebrated the ruling, saying Illinois just beat the Trump administration in federal court. Their case challenging the bipartisan Trust Act was dismissed. Unlike the president, we follow the law and listen to the courts. The Cook County State's Attorney, Eileen O'Neill Burke, also praised the ruling, saying the Trump administration's continued attempts to bully local communities into adopting their preferred policies are not only unlawful, but counter to our values and ability to fight crime effectively. However, the White House responded by saying that cities like Chicago make Americans less safe and that the government has a duty to protect citizens from harm. The controversy surrounding sanctuary city policies is unlikely to die down anytime soon, with the Trump administration vowing to continue its efforts to enforce federal immigration laws. But here's the question. Do sanctuary city policies really make Americans less safe? Or are they the necessary protection for vulnerable communities? And this is the part that sparks debate. Is it the role of local governments to enforce federal immigration laws? Or should they be able to set their own policies? The answer to this question will have significant implications for the future of immigration enforcement in the United States. As the Trump administration continues to push for stricter immigration laws, cities and states are likely to resist, leading to more lawsuits and more controversy. But one thing is clear. The issue of sanctuary city policies is complex, multifaceted, and unlikely to be resolved anytime soon. So, what do you think? Should local governments be able to set their own sanctuary city policies? Or should they be forced to cooperate with federal immigration authorities? Let us know in the comments.